te loi bi nak dafa teggi ci ñi nga xamne ñoo amé karange gi wala ndaw buuri bu daf leen ko teggi.
That ensued from this April 10 and 11 incident.
Ci lo xamne sax mu ngi fa xéko ci xew-xew.
Can't you see that? I was nowhere near the Gambia in 1982. I was in England.
Why na nekkul loo xam ne jaadu na ndax bés bi muy commencé mooy atu ci wet ñaari fan ci weeri August 1982 te jamono jegewuma sax Gambia.
The amendment, that's what we are referring to, the amendment.
Where is it?
And the amendment is right there. Read section 1 of that amendment.
Section 1 says, this act may be cited as the Indemnity Act. Every act which is amended under the Constitution, Section 226, you must state that it's an amending act.
Can you continue reading through, please?
Yeah, just a minute. Every act which is amended must state that it's an amended act under the Constitution.
Loi bu ñu roxandi ko rek ci biir loi bi wane na ne dañ foog si rek ju wane fa ne lii loi bu ñu roxandi la.
If you don't do that,
boo ko defutee rek
it's not an amending act.
nekkul loi boo xam ne ni dañ ko roxandi.
And this act started in 82. I didn't take it to the National Assembly.
lii mu ngi commencé 1982 te du man maa ko yóbbu ci néegi député.
And it was not a public emergency, April 10.
te April 10 nekkutoon nag jamono boo xam ne ni jamono jëlbatu la.
Because it wasn't declared. It wasn't so declared.
ndax yébaane wu ñoon.
Read through it, please.
Which one? The whole act?
The first part of it. Or
Okay.
if you may, I can read it loud for the commission.
Date of commencement. Government, etc., not liable, except as otherwise provided by the act. The government or any agent of the government or any person in the service of the government or any authority acting on behalf of the government shall not be held liable for any act, matter, or omission to act or thing done or purported to have been done. In pursuance of an act of the National Assembly or under the authority of an act of the National Assembly that authorizes the taking during any period of public emergency. You see, that's why they are talking during any period of public emergency. It's a technical term of measures that are reasonably justifiable for dealing with the situation existing in the Gambia during the period of the public emergency. In the execution of a duty imposed by a law for the defense of the Republic or the enforcement of discipline or the securing of public safety, public health, public morality, or otherwise in the public interest on or after the 30th day of July 1981. And during any unlawful assembly, public disturbance, riotous situation, or period of public emergency. The President may, for the purpose of promoting reconciliation in an appropriate case, indemnify by an order he or she may determine for any act, matter, or omission to act, or thing done or purported to have been done during any unlawful assembly, public disturbance, riotous situation, or period of public emergency. You want me to continue?
Stop there. Thank you very much.
You're welcome.
It is quite clear from the wordings of that particular act
leer na nañ na ci ni nga xamne ñoo lañ bindé kàddu yi fofu
that the intention behind the act
ne li nga xamne modi jublu way loi bobu ñu dugal
was to protect officers that were directly responsible for harming students during April 10 and 11.
loolu moo wane ne lii mu xew-xew bi amoon moo tax dañu yëkkatiwaat lu
And in fact,
jamono jëlbatu yooyu.
was anyone prosecuted after the bill?
ak jamono yi nga xam ne ci nga gën a feeñal luwaa bi
There was an uproar
amoon na beneen xew-xew
with respect to civil society
yi amee wàlli yelleefi doomu aadama
about the draconian nature of such an amendment.
ak lu aju ci anam yi ñaaw yi nga xam ne soppale yi ñu def ci luwaa bi moom la méngoo.
And what did you do?
loo def nag ci loolu
I just told you, it didn't protect them. Public emergency must be declared. It's not a technical word. These are legal terminologies. If you go to the Interpretation Act.
Comme ni ma la ko waxee rek aarul leen ndax amutoon nag jamono boo xam ne yéebaane nañ lu jëm ci wàllu public emergency.
Chapter 5 of our laws.
Suñ juróomi buntu bi ci suñ luwaay réew mi.
And under the Constitution definition section, you will see what a public emergency is. If it is not declared, it will not be a public emergency. So if the government decided not to prosecute, as far as I know, it was for national security reasons.
Kon nag bu fekkee ne nguur gi bañoon nañoo àtte ñooñu comme ni ma ko xamee rek mooy lu aju ci wàllu kaaraange réew mi.
And as far as the facts of the issues were concerned, there was actually no national security to even rely on in the first place.
su fekkee ne mun nañoo seet digga gi nekk ci mbiram sax amul loon dara loo xam ne kaaraange réew mi la loo xam ne ci lañ doon mun a sukkandiku sax.
Acts such as killing,
lu mel ni rey,
and inflicting harm on citizens
ak di teg ay mitit ci kaw ay doomi réew mi
cannot be sheltered under national security.
loolu mënut a laxu ci ron kaaraange bi réew mi.
As for the president, national security is the province of the president. I cannot say, as you are saying, there was no national security element. You cannot do that.
Lu jëm ci wàllu kaaraange réew mi daal loolu mu ngi nekk loo xam ne nii mu ngi dëppoo xalaati président.
All I can say is that public emergencies must be declared to become public emergencies. That act deals with public emergencies.
Comme li ma la waxoon rek public emergency na foog si rek ñu dal di ko déclarer mu mun a nekk public emergency.
Sometimes in the Gambia, people think they actually know what the law is from just hearing people in the street. But if you read it, you can see it says public emergency. It must be declared.
Kon nag am na ñoo xam ne nii dañuy foog rek liñ foog rek mooy léegi dara si réew ci nit ñi ci mbedd mi ne public emergency waaye foog si rek mu nekk nag lu ñu.
Mr. Witness, I may be a relatively young lawyer compared to your long standing in the bar.
Mr. seede bi xam naa ne buñ ma méngale ak yow roya bu ndaw laay nekk ci sa ron suñ ko méngale ak yow ni nga yàggee ci wàlli bunti àtte bi.
But I am of the opinion
waaye nag xam naa ne
that this particular act with respect to the quote public emergency
ne luwa bi nga xam ne moom lañ dugal ni lu aju ci taxawal luwa jàppandal yooyu
also covered the incident of April 10 and 11.
loolu tamit laal na xew-xew yi amoon April 10 ak 11.
There's nothing like a small lawyer in my book. They are all lawyers.
Well,
but, let me tell you once again that it's clear there. Public emergency, it's a hurdle you have to pass. You must jump that hurdle and have it declared as a public emergency. He didn't do that. So relying on it as a public emergency will not cut ice. It was not a public emergency. So they could have been prosecuted.
No, they couldn't have been prosecuted. Because it says during any unlawful assembly, public disturbance, riot situation, or period of emergency.
Yeah.
It covers it, Mr. Witness. It does.
You have to show that it's an unlawful assembly. The only place where you can show that it's a public emergency is before the courts. And that court has to look at it and say, okay, the assembly of the students was unlawful. You can't just read it and say, because government said it was an unlawful assembly, so it was unlawful. No, the courthouse is where to determine that.
Ci court bi rek lañ mëna wérélé né ndaje bobu xalé yi dajé won depo ton ak yoon.
But in this regard, Mr. Witness, it does cover it. And them as the chief legal advisor to the government, the custodian of justice, as at that time, you presented the bill, denied justice to a lot of students at that time, and you remained silent about it.
Oh, don't be offensive. You are very wrong, actually, to say that. I've told you that this act started on 2nd August 1982.
Bu ko gisee maire de waaye nag li nga wax noonu nekkul loo xam ne ni noonu la ndax lii mu ngi dooree ci ñaari fan ci weeri August 1982.
I wasn't there.
Te nekkuma woon fa.
Secondly, whatever amendment I presented,
ñaareel ba ci bëre roxandi boo xam ne ni teewal naa ko.
It not prevent the prosecution of anybody. It's there. Either it has to be declared a public emergency, which was not done, or it has to be declared lawful, not by the president, but by the courthouse. Only the courthouse can do that.
Amul dara loo xam ne ni aar na leen ndax mu ngi fa ndax du loo jamono boo xam ne yéebaane nañ ne jot boto am na di public emergency te tamit nekkul na loo xam ne ni président bi moo wax rek ne seen ndaje bi dëppoo ak yoon ñu war koo lini loi bi moo ko war a nangu ne daal seen ndaje bi dëppoo ak yoon.
Thank you very much, Mr. Witness. I don't take things personally. I'm just doing my job.
No problem.
No worries about that. But with respect to this particular provision of the law, we can agree to disagree. But it covers unlawful assembly, public disturbance, riot situations, or periods of public emergency. And the law is clear on what unlawful assembly is and what public disturbance is.
Take it to the courthouse. They are the ones to determine that.
But you presented a law, an amendment, that gave a retrospective effect. A retrospective effect to a crime that was committed some months ago. And sadly, this is still in effect. It can still be used by the government to violate the rights of citizens in this country.
No, as you say, you can go on. I'm telling you that that's wrong. It has to be declared unlawful, not by anyone else but the courthouse. Take it there. Take it to the courthouse. And I was not there on 2nd August 1982. This act says commencement date 2nd August 1982.
August 1982
It's not my responsibility. And on that commission, I told you what we did. We said it was wrong. In cabinet, I sponsored a paper to say pay.
My apologies. Just give me a brief period to read through this. I can't see clearly. Mola, can you kindly assist in printing it, please? There is actually a judgment of the court on that particular issue that I would like to bring up.
Feel free.
dogal biñ defoon ci wàlli atte bi loolu laa bëgg a indi pour feeñal ko.
But while we wait for that,
comme que ñu ngi koo xaar na pour ñu indi ko.
we can just go on, and when it comes, I will make reference to it.
ñu jël leneen bu ñëwee nag ma wéeruwaat ci loolu.
Feel free to ask anything, please. I told you earlier. Feel free.
Well, I am doing just that.
Council, just a second.
Yes.
Commissioner is asking, making a point of order. Commissioner Bishop.
I want to ask a question, please.
Yeah, please go on. It's a point of order.
Yeah. Now, what is confusing is the amendment that you are talking about, that he passed.
li nga xam ne moo jaaxal fi mu nekk mooy wécceeku yi nga xam ne moom nga wax ne moom moo ko dugal.
When did he pass the amendment? Because he's constantly referring you to 1982.
dañ la ko dugal ndax te yow jamono saa yu nekk mu ngi la wax ne nga dem ci 1982 la xewoon.
The amendment was actually passed in April of 2001.
wécceeku bi nag ñu ngi ko defoon weeri April 2001.
But it appears as if that amendment date is not there.
I cited Act number 5 of 2001. You remember he became the minister.
So, but perhaps you need to point to that amendment date.
He is well aware of the dates, I believe.
What's the date?
The Act number 5 of 2001.
2001.
What
Yes,
Bishop is asking.
As amended by Act number 5 of 2001.
What's the date of the amendment?
2001.
Oh, the actual date. No.
Yes, that's April 2001. I have with me an observer, a daily observer paper that will help us situate the date.
am naa kayit daily observer boo xam ne dañu mën a dimbale ci bés bi.
I'll just state what happened before the National Assembly as it was reported by the Daily Observer.
comme ni nga xam ne noonu la xewee woon te néegi député ya ni ko kayiti xibaar yi daily observer feeñale.
In fact, the paper reads, "The indemnity bill, was it validly passed?" That's the title.
ñu ne ndax luwa boobu nga xam ne moom lañ tëlaloo maraani kiiraay yooyu ndax jaaral nañ ko war a jaarale.
And it's an editorial actually.
te loolu ñi nga xam ne ñooy bind kayit yi ñoo ko binda.
Written by Frederick Rumpel.
Frederick Rumpel nag moo ko binda.
The report in your issue of April 19.
xibaar bi nga xam ne moom ngeen feeñal ci li xewoon April fukki fan ak juróom ñeneen.
Headed Sidia Amat marched out.
ñu bind ci ne Sidia ak Amat dañ génn.
On the proceedings of the National Assembly on the indemnity bill.
ci jamono ji nga xam ne néegi député yi ñu ngi doon waxtaanee mbiri luwaay yooyu nga xam ne dafa teg malaani kiiraay ci ñenn ñi.
So this tells us that the bill was passed somewhere around April. I don't know if it is April 19th exactly, but it's April, maybe before the 19th or so. But it stated that on Sidia and Ahmad marched out on the proceedings of the National Assembly indemnity bill.
wane nañ ne Sidia ak Amat ba ñoom dañ génn ci néegi député yi jamono bi nga xam ne ñu ngi doon waxtaanee mbiri luwaa boobu.
Which many right-thinking Gambians, including your editorial of the same issue,
xam ne lu aju nag ci ñi nga xam ne ñoo am xalaat ci waa Gambia ak lu aju ci bindam yi ñu def nii.
considered a great act of impunity and a cover for misdeed.
Gis nañ ko noo xamee ne ñu ngi lax jëf joo xam ne def nañ ko te jaaduwul.
Raises an important point.
te loolu nag wone na fànn goo xam ne bu am solo la.
The total membership of the assembly is 50. That was during that time.
jamono booba day ñu nekkoon ci néegi député juróom fukk lañu woon.
According to your report,
ci yow xibaar bi nga génnee.
18 were absent.
fukk ak juróom ñett nekkuñ fa woon.
The report is actually questioning whether there was quorum. Was there quorum?
ndax report baa ngi wax ne sax ndax amoon nañ lim bu jaroon ñu war a toog jataay boobu.
4 voted against.
am na ñeneen ñoo xam ne ñoom ànduñ ci.
5 in abstention.
juróom yoo xam ne ñoom bëgguñoo wone fan lañ far.
Two walked out of the proceedings,
ñaar ñoom génn nañ.
and as you concluded rightly, only 21 out of 51 voted for such measures.
mel ni ñaar fukk ak yéen ci juróom fukk ak benn ñoom rek ñoo bokk ci mbir mi.
It is
ñoo ci ànd.
thus quite clear that the bill has not received the support of the majority of the National Assembly members.
te loolu feeñal na ne lii ñu dugal nii mu nekk luwaa député yi ñëpp ànduñ ci woon.
Only a minority of the members voted in favor of the measures.
ñu néew rek ñoom ñoo ci àndoon.
The editorial now question whether the bill was validly enacted.
léegi nag ki dugal lii di laajte nag ndax luwaa bi doxal nañ ko jaarale ko niñ ko war a jaarale.
As you can see, this was quite controversial even at that time.
comme niñ ko gisee de lii doonoon na loo xam ne indi woon na werante bu rëy sax jamono booba.
Many of the National Assembly members believed that
am nañu ci bari yoo xam ne ay député lañ ñoom liñ gëmoon mooy ne
it was a cover-up for the misdeeds that occurred during April 10 and 11 incident.
lii daal dañ ko def rek pour nëbbatu laxatu ci xew-xew bi nga xam ne moo amoon April 10 and 11.
I don't think so, really. Again, the Indemnity Act had been passed earlier, indemnifying some officials in respect of what happened in 81, the aborted coup. Now, over there, unless it is declared unlawful in those sections by a court, nobody can conclusively say the acts of the children were unlawful. Let them test it.
Comme niñ ko waxee rek indemnité boobu li nga xam ne mooy maalaanam càngaay googu noonu kaaraange googu dafa nekkoon depuis atum 1982 te itamit nag ci bunte yooyu nga xam ne noonu lañ ko loxandee day amul fenn foo xam ne ni wéral na ne xale yooyu seen daje bi dëppawutoon ak yoon foog si rek mu waroon a jaar ci bunte attekaay boobu.
Need I remind you, Mr. Witness, that the Commission of Inquiry report stated that the acts of the children in staging a protest was unlawful.
ma fàttali la nag ne xibaar bi nga xam ne moom lañ ca feeñal mooy ne xale yi pour ñu dajale seen boppa di wane seen ñaxtu yooyu àndul ak luwa.
And you were part of that commission.
Even there, even if we said that, is the courthouse. A commission of inquiry cannot conclusively hold that kind of thing. It's the courthouse which can decide that.
Donte foofu sax ci commission of inquiry sax nga xam ne nii bokkoon naa fa même su fekkee ko fa sax court bu mag court rek moo mën a dëggal loolu.
Yeah, but it's not the 1982 act that is in question at the moment. What Bishop was asking about, which is a very valid question, is the amendment. And we're trying to find out what the date of that amendment was. And you were around as Attorney General, Minister of Justice, and I believe you have 3 hats on at that time. There's a Minister for National Assembly Affairs. What is being inquired at the moment is the date for the amendment.
Yeah, I can't tell the exact date.
Well, somebody must be able to tell us. You can't have laws of the Gambia out there, and you don't. Nobody knows here when that amendment was passed.
Yeah, because it says number of 2001.
I'm not worried about that. All I want to know is when was that amendment passed?
Yeah, I can't say the exact date. No.
Mr. Chair, if I may come in, it's not an issue of when, because the when has already been established. It was during his time as Attorney General.
The date we want to know, because he's the one just questioning.
The amendment, as it is stated in the law, it's cited like this: Act number 8 of 1982, amended by number 5 of 2001. But the month is not stated. It's the year in question, and the year in question, he was the Attorney General, which he admitted that he was the Attorney General. And he has also admitted that he was the one that tabled it before this particular amendment, before the National Assembly, if I'm correct to say so.
You have to guide me on that. I can't say anything now off the cuff. 2001, I became minister end of January. I think I started my functions either 1st February or whatever, but I was appointed around the end of January.
If I may, speaking from the bar, like speaking with authority here, I did make an inquiry with the Ministry of Justice as to whether he was the one that tabled the amendment before the National Assembly, and they confirmed that yes, he was minister at that time and he tabled it before the National Assembly.
Amna gestu bu ma def nak ci suma wàlli liggéey pour laajte ndax jamono ji nga xam ne ñu ngi wone soppali yiñ def ci wàlli luwaa yooyu moom moo fa nekkoon ministre bi saytu wàlli atte gi te wëraloon nañ ma ne waaw moo fa nekkoon.
Chairman, I think council has also read an article. And what's the date of the article?
And the article I read is dated, sorry, my apologies.
April 19th.
April 19th. That was when they stated that Cedia walked out of the proceedings of the National Assembly, and he was appointed sometime in January as Attorney General and Minister for National Assembly. So it is within his time or his tenure as Minister of Justice.
Wali ñu ko binda wéri April ci at moomu noonu te moom wéri January lañ ko defoon ministre bon dafa mel ni jamono boobu mu ko fa fekkoon.
I stand to be corrected, Mr. Witness. If that's not the case.
As I said, I'm not ready to be volunteering dates which are 20 years ago, but you can do that.
Wax naa la man nekkuma ko fi mën a nekk rek di seet bés déet yeeg yooyu noonu bés yu nekk ndax loolu about lu dem ci ñaar fukki at ci gannaaw la.
Mr. Chairman, if we can just skip this point, I can undertake to provide the bill that was actually presented before the National Assembly bearing his name. That will be tendered as exhibit to show that indeed he was the one that tabled it before the National Assembly. But not today, Mr. Chairman.
I would want to have a consultation conference with the two of you at some point. So maybe you can skip this point now and then find out exactly what is happening and inform the commission. We can't go on like this and that we don't even know the datum of effectiveness of the amendment.
I'm grateful,
that.
Mr.
He mentioned retroactivity. That's
Yes.
very important. That's why I'm insisting on wanting to know when the amendment became effective.
Certain that it was April, Mr. Chairman.
Well, anyway, let's have a consultation thing and then try to sort it out. We can't
Very
do it like this at the moment. But continue, Council.
Mr. Witness, just to take a cue from Chairman, we'll move to other issues while we'll try to verify these other issues that have come up.
Léegi nag ñu continuer ci leneen bala ñu jeexal lii.
I will come back to the amendment on the Indemnity Act.
Dinaa dégg nag ci mbiri soppale nga xam ne moom lañ def loi boobu.
Just so as we will not waste time,
Pour rek ñu bañ a tardé.
you also initiated several amendments on the Constitution.
Yow nag am na ay xalaat yu bari yoo xam ne def nga ko ci soppali yuñ def ci loi réew mi.
And one of such is the inclusion of secular in Section 1 of the Constitution.
Benn bi bokk na ci dugal mbiri secular moo di réew mi du dox ci benn diina dugal nga ko woon ci mbiri.
What can you tell us about that?
That is correct. We initiated that.
waaw dëgg la commencé woon nañ loolu ñoo xalaatoon loolu.
I think the idea was there was a communication of people coming in with extremist views, and intolerance was growing in the Gambia. And we felt that it was important or opportune to nip it in the bud, because the Gambia has always enjoyed peaceful coexistence among its various groups of people.
ndax am na yenn jamono wu daal ni ñange xabaabal di jéggi dayo ci mbir yu mel noonu tey tamit daal ñàkk masla mu ngi doon am ñu gis ne jaroon na itamit nag pour ñu dugal ci lu mel nii ndax jamono Gambia nekk na réew moo xam ne ni ci diir bu yàgg ñu ngi bànneexu ci jàmm ak dëkkin bu neex.
And we saw what was happening in other countries where extremism had taken hold.
tey tamit gis nañ nag li nga xam ne nii moo daan am ci yeneen réew yi tey tamit nag ñu gis ne daal yu xabaabal yi naka la daan amee foofu.
So we felt it was a good time to bring in that kind of amendment to help all Gambians, not just majority or minority, everybody in the Gambia.
bu ko defee nag ci lañ wax ne daal war nañoo indi nag loolu ñu daal di def soppali mbir moomu ndax bu dimbale nekkul rek benn boor ci Gambia waaye ñëpp ñu.
Lañ xalaatoon na pour jóge ci
Kemeseng Jammeh before the Supreme Court,
dingatul na ko ci kanami Supreme Court bi,
stating that that particular provision of the law was entrenched.
de wane ne li nga xam ne boobu ci loi bi la génnee nañ ko fa.
And the inclusion of the word secular was null and void.
Li tax ñu dugal ci kàddu googu secular loolu amut njëriñ.
And of no effect, which provides for the manner in which to deal with entrenched clauses that are in there.
Ndaxte àndul ak li nga xam ne mooy fànn bi ñu def ci wàlli loi bi ci ay soppal yoo xam ne dañ ko def ci loi réew mi.
Can I get your reaction on that?
Wow, amoon na ci boo xam ne amoon na.
But ask whatever you want.
As at the time when you were making the amendment,
jamono ji nga xam ne yaa ngi doon def soppal yooyu,
you knew that that particular provision of the law was entrenched.
Not entrenched, as far as I'm concerned.
Nekkutoon loo xam ne dañ ko séddale ne kenn du ko mën a wëlbati.
But the ruling of the Supreme Court in the case of Kemeseng Jammeh and the state
why Supreme Court bi liñ dogaloon ci mbiri Kemeseng Jammeh ak
clearly state that that particular provision of the law was entrenched and it should not have been tampered with.
Wane nañ ne fànn boobu ci wàlli loi bi dafa mel ni dañ ko ñàkk amul kenn koo xam ne war na koo mun a laal.
That came later. That came later, but when we took this particular amendment to the National Assembly, at 226, subsection 4 applies to sections 1 and 79.2, which relate to the sovereignty of the Gambia. That's very important, because in the interpretation of statutes, what is in brackets will not occupy second place. It's as effectual as all the words which are outside. And our reading was that it was only dealing with what unsecular republic. So we amended the republican nature of the Gambia, not the sovereignty of the Gambia, which section 1 was entrenching.
Mooy nag li nga xam ne mu ngi jëm ci xat boobu nga xam ne dañ ko ñàkk ne kenn mënu koo wëlbati ñu seet si na ñaari xaaj benn xaaj bi nag li nga xam ne mu ngi jëm ci wàlli réew mi ne moo nekk na réewam boppam ak li nga xam ne mooy mbir lu jëm ci wàlli sécular boobu ñu ko ñàkkoon.
Just a minute. Otherwise, why would the section 1, if it's so clear and it's saying sovereignty, why should the draftsman go on and say which relates to the sovereignty of the Gambia? It's already known that sovereignty is in section 1. Why should they go on and try to explain to people that that section relates to sovereignty of the Gambia? There would be no need. Otherwise, the republican aspect should have been in a different subsection, but it's in the same section, so that those words relates to sovereignty of the Gambia. Republican status does not necessarily relate to sovereignty. It's a different thing from sovereignty. So you can amend what is not referred to in the brackets, which is anything other than sovereignty. And so we did that.
Mu ngi mel ni comme booy roxandi rek wala ci wàlli coppali yoo xam ne dana am nekk ne li nga xam ne dañ ko ñàkk loolu moom mooy li ci des te moom mu ne def nañ ko ñoom.
Mr. Witness, regardless of your interpretation of that particular provision of the law,
dafa des nag ci yow ni nga xam ne noonu nga feeñale fànn boobu ci wàlli luwa bi.
The Supreme Court,
bi
which is vested with the authority to interpret
nga xam ne moom jox nañ ko doole pour mu layoo
and determine the validity of a particular provision of the law,
pour mun a feeñal luwa ni nga xam ne noonu la war a tëbee,
made a ruling with respect to the amendment you introduced and said it was null and void. It is the Supreme Court that has the power to do so.
The Supreme Court
imputed the word secular in an entrenched provision of the Constitution.
Ya dugal baati secular ci loi boo xam ne dañ ko ñàkk maanaam dañ ko aar ba nga xam ne waruñ cee soppi dara waruñ cee yokka wàññi.
The Supreme Court
bi
ruled that
dogal na ne
the word that you have imputed into the 1990 Constitution
dugal ko ci loi yiñ tëraloon atum 1997
was there.
Ni ngeen ko fa dugalee àndut ak loi.
And therefore that particular word, the addition of that particular word is null and void.
Ko loolu nag pour yokka baat boobu ci biir loi bi moom amul njëriñ.
The Constitution that people voted for in 1997,
loi bi nga xam ne nit ñi dañ ko ooteel atum 1997.
Even though we've received extensive evidence that certain provisions were removed.
Dëgg la sax am nañ ay xibaar yoo xam ne wéral na ne yu ci bari dañ ko ci rocci.
But then that is the Constitution that was voted for by the people.
Waaye loolu loi la boo xam ne nit ñi seen boppa ñoo ko ooteeloon.
So you in turn
yow ngeen ñëw ulbatiku
decided to add another word that was not even there before.
Dugal ci benn baat rek boo xam ne nekkut fa woon.
And the Supreme Court,
bunti attekaay bu mag bi,
which is the Supreme Court of the land,
nga xam ne mooy attekaay bi
vested with power to determine the validity of a particular law,
te moo am doole pour wone taxawaay loi bu mun a doon,
and the interpretation of the law.
Ak ni nga xam ne noonu laa waxee loi bi lan la umba.
It provided that that word, putting that word there, was unlawful and it was null and void.
wax na ne nag pour dugal baat boobu ci biir loi bi loolu àndul ak loi kon nag amul njëriñ.
Is that not the case here?
loolu du moo woon li xew.
What I'm saying, madam, the court has made a decision, but you then have to go back to the constitution, which says, if you remove a comma from this constitution in a section which is said to be entrenched, and the court has held that section 1 is entrenched, and the word is in an entrenched provision, you have to look at subsection 4, and it tells you any bill shall be passed. You have to pass a bill to remove that as well.
Comme ni ko waxee woon rek bu fekkee ne court bi dal dina def dogal bu mel noonu tey foog rek ñu wuññeekuwaat ci loi réew mi ndax bu fekkee nag ne loi la boo xam ne ni dañ ko ñàkk te wecceeku foog si rek mu war a jaaraat ci génne benn loi teg ci beneen loi.
Secondly, I did not pass that amendment.
ñaareel ba du man maa àggale nag amendment bu loi boobu.
I always like to enlighten some of our people again. The procedure for passing an act is the MPs are the people who pass it, and the president will sign and assent to it. Then it becomes an act. Not Joof or the Ministry of Justice. They cannot pass any act or any amendment.
Te it ma leeral fii pour wéral nag loi boobu noonu bu néegi député yi ñoom ñoo ko war a sànni nangu ko président bi dal di ko yéwénal waaye nag du Joof wala ministre bi saytu wàlli loi ak àtte moom moo koy def.
You, Mr. Witness, presented it before the National Assembly.
You don't pass it. The two are different.
You tabled it before the National Assembly.
An act is not passed by the minister presenting. It's passed by two sets of people. MPs, president. You have an act.
Loi nag li koy dëgëral mooy li koy taxawal mooy ñaari bunta néegi député ak président bi nga am bunta.
No minister can pass an act.
Mr. Witness, did you or did you not this particular amendment to the 1997 Constitution before the National Assembly?
I said I did it, but I didn't pass it. These are terminologies.
So you tabled it. You're admitting that you tabled it before the National Assembly.
I told you I did. I tabled it. I presented it. But I cannot pass an act or an amending act. Only the MPs and the president signing, assenting can do that.
As chief legal advisor to the government, you are supposed to advise the government on legal issues, correct? And it is through your advice that the government carries out certain things. And in fact, you are the chief draftsperson for the government because every bill passes through your office and you table for the National Assembly.
Let me guide you there. When bills, so agriculture, everybody can sponsor a bill. Now they can go through the drafting section.
Ci ministry bi saytu lii ministry bi saytu lele buñ paré na ñu jaarale ko na ci ñi nga xamné ñoo koy bind.
When it is not presented by the minister
saytu wàlli loi ci réew mi,
when they finish they take it back to the particular ministry, local government, fisheries, agriculture, and they present it before parliament.
Bu koy fé nak boba buñ bindé loi bi paré dañ koy délowaat ci ministre bi nga xamné Mr.
Witness, just a quick question before you proceed.
That did not come to me as minister. Only bills which were to be tabled, sent to parliament or presented by the Minister of Justice and National Assembly Matters or the Office of the President.
Mr. Witness, where is the drafts, legislative drafting office? Where is it?
There's an office in the Ministry of Justice.
And it's under your ministry, correct?
Yeah, it is.
Wow.
But not every bill will come to me as minister. That's what I'm saying.
But as
Minister of Justice, you assume responsibility for every bill that is passed under your office.
No, I cannot. Those who present their bills, they take responsibility. My staff will help them in drafting, but that's where it is.
Mr. Witness, in this case, are you running away from responsibilities, if I may ask?
I never do that. I never do that.
Because this particular amendment, Mr. So did testify before the commission that you tabled this particular amendment before the National Assembly, amending an entrenched provision of the Constitution.
I took it there. I don't know why you keep asking that. I said I took it to National Assembly. And it was, as far as we were concerned at the time, that provision was not wholly entrenched. Only the portion relating to sovereignty was entrenched. As you can see the words in the brackets, it says relates to the sovereignty of the Gambia.
What the
Republican status, which is what we amended.
And given that proper procedure was not followed in carrying out this particular amendment, it created more room for the executive to tamper with the Constitution, because this was the first of its kind.
They were more interested in sovereignty, not whether it was a republic or something else.
Mr. Chairman, I'll leave the commission to decide on this, to come to a conclusion as to this particular issue. So we're also introduced by
Very well.
an amendment was made of 2001.
At number 6, 2001.
Giving powers to the president to appoint chiefs.
I said.
Now, the preamble of the amending act would probably say that. But as far as I'm concerned, I think the idea was to ensure that every Gambian is able and entitled to be a chief. Once you are a Gambian and you meet the basic requirements, you should be in a position to be a chief. You don't have to be born into a particular family to be a chief or alcalo. We didn't share that view. I don't share it. I still don't.
Kanal do jubluwaay bi moo nekkoon ne képp koo xam ne doomi réew mi nga yow yelloo nga nekk chef ci réew mi tànn waaye na du ne rek da nga war a jóge ko ci genn façon ngi njaboot rek benn géñoo rek pour nga nekk chef loolu moom man àndu woon ci bi tey.
Prior to this amendment,
lu jiitu
there was already a traditional system in place that was working well for the people.
Why are you saying working well, madam?
If you may, let me just proceed with my line of questioning. Thank you. A case was instituted against the government. That is in the case of Jabi versus Keba Fanta Koma and others. This case was as a result of the president appointing an alcalde. No, sorry, a chief. And the individual, that is Jabi, who had the authority to stand as chief, was denied his right, and he took the matter to the Supreme Court. And when the matter was before the Supreme Court, they ruled in his favor. Supreme Court, which was in 2000. That the state introduced this amendment. And it is argued that the amendment was done so as to give Jammeh the control over traditional leaders. And not necessary to provide qualified Gambians the right to become chiefs or alcalos. It was a strategy to entrench himself in power.
I don't think so. I don't think so. You see, these are all political matters. You can always fit in something in there.
Yeah,
like you're playing football, as you walk along the sand, you kill an ant. It happens on the way.
Play football.
Mr. Witness,
what was that in the past, especially in some parts of the country, a particular family was inheriting this chieftaincy. We are not doing it properly.
Nepotism
corruption and all kinds of things were coming into it, and that was to stop it.
And you decided to give the total authority and power to one single individual who also used the same tools and even in an enhanced form. Tribalism, nepotism, in his selection of alcalos and chiefs in order to entrench himself further in power.
Anyway, as far as I'm concerned, the reason was to give Gambians more opportunities. You can't be in your country and then you cannot occupy certain offices.
Pour nak ñu mëna am falute yoy ndax nek rek ci réew mi té mënulo fexé ba falu ci dara.
Mr. Witness, if that was indeed the reason for it, Don't you think that there could have been other safeguards in the local setting?
If you've been throughout the Gambia, as I have been, and you know the local areas and how our societies are organized, you know that there is no other way to remove a chief or an alcalo and put in somebody who's been to school or somebody who's more qualified. The people are under his constant authority, the chiefs and alcalos.
Commissioner Kinte wants to raise a point of order. Can you please go ahead? She is just too young. That's why he couldn't defend her case. The chieftaincy was based on the semi-autonomous democracy. It was
You want to know about the Gambia entertainment industry. You want to know the existing policies and programs of the arts and culture sector. You want to know about the governance and management of the arts associations. The program will throw a fresh light on the entertainment industry in focus. We will touch so many angles about the cultural sector, the opportunities and challenges, and interrogate them, and most importantly, offer solutions.
Ngali yende o kwa nyulle nata ka musicolu kidimandi nyulle nata ka artisolu kidimandi nyulle nata ka jado ganyandi nyulle nata o ka jololu fanam fintindi Facebook oto
the president.
YouTube Facebook oto ko YouTube Gambia talent
President bi pour mu dugal loxoom ci li nga xam ne noonu lañ aada woowoon daan jëlee seen
No, madam, I don't agree with you. It wasn't working well at all. Anybody who knows the provinces, and I know the provinces.
yow ci loolu de nim doon ci kaw gi yëpp
you see that the chiefs used to come
wala besa fatoto rek waaye rek ci genn geño gi rek la
you need in
foog si nga ndigam am nga yelleef yi wote war nga falu
and somebody must appoint you. Somebody has to appoint the chief.
Tamen fekk ci kenn ab tànn la.
Did the chiefs and alcalos protest as to the manner in which things were done? Did they send a position paper complaining as to the manner in things were done during that time?
Chef yi ak alkali na am na yeen kayit yoo xam ne wane nañ ko di tawat anam yi nga xam ne noonu la mbiri daan doxee jamono boobu.
What do you mean? Protest to who?
Did they send a request or a protest paper stating that the traditional means in which they selected their chiefs or their alcaldes was not working for them?
Ndax yónnee nañ kayit boo xam ne ñu ngi cee wane seen ñaxtu bu wane ne anam yiñ tànnee alkali wala chef yi neexut leen.
I don't know. All I know is that we were given the mandate to present this amendment to the National Assembly, and we did.
Xawma daal ndax ñun daal li ñu sasoon rek mooy ñu dal di dem yóbbu lii pour ñu roxandi ko wala soppali ko ci néegi député yi te def nañ ko.
I still think it was right.
Ba tey yaakaar naa ne loolu jaadu na.
Did the president give an opportunity to the communities to vote as to who will be their chiefs before he selects the individual, have him to be chief over them?
Ndax président bi joxoon na doole ñi nga xam ne ñoo dëkkee ci tunda yooyu pour nag ñu tànn ki nga
did that. Chieftaincy in Gambia was hereditary. It should not be hereditary. It should not be hereditary.
Can't get into the debate on that one. No, just a second.
Since that is not the case either, that means that you gave powers to an individual to dictate as to what communities, the leader that the community should select. Sorry, if I may rephrase that, to dictate a particular or to impose a leader on the communities. And that on its own encourages dictatorship, Mr. Witness.
I don't agree with you, definitely.
Well, it does. I'll give you an example. Mr. Chairman, if you may recall, Mr. Kemeseng Jame testified before the commission. An incident that happened in his village. The community leaders met and selected an alcalo. The president imposed another alcalo on them. And their rates were rejected because they paid to the alcalo selected by the community. And to make matters worse, the chief sentenced them to 6 months for not paying their rates to the alcalo that was selected by the president, that was imposed on them, rather, by the president.
I don't know the details of these cases and the background, but truly speaking, every Gambian is born free and equal. They have a right to be chief, president, or alcalos, as far as I'm concerned.
Xam nak mbir mi nak fu mu jóge ko ak nu mu mujjee de waaye nag li ma mën a gaaral mooy doomi Gambien bu ne am na yelleef pour ñu tànn la nga nekk njiit.
Mr. Witness, the amendment that you tabled before the National Assembly, giving absolute power to the president to select chiefs and alcalos for our communities, created several problems, political problems in this nation.
bi nga xam ne moom ngeen feeñal ni pour dooleel président bi muy tànn ay njiit ci tunda yooyu noonu indi dina jafe-jafe bu rëy boo xam ne
If you want to receive monies from UK, Europe, USA, Canada, Switzerland, and the rest of the world, Supersonic's money transfer has got you covered. With the largest payout network in the Gambia, you can now receive your monies anywhere you are, from Kartong to Koina, with less hassle. Yes! You can receive monies from your family and friends in UK, Europe, USA, Canada, Switzerland, and the rest of the world with our safe, secure, fast and convenient service that offers you the largest selection of payout locations in the Gambia. Supersonic's money transfer. We are currently in 34 African countries and counting, giving you quality money remittance services that are second to none. Visit the Google Play Store or the Apple Store today to download the Supersonic's money transfer app and enjoy excellent money transfer services only with Supersonics.